I want to thank everyone for being here for today's Civil Justice Full Committee. Madam Clerk, will you go ahead and take the roll, please?
Representatives Bricken, Clemens, Curcio, Eldridge, Garrett, Gillespie, Griffey, Harris, Littleton, Ogles, Parkinson, Ramsey, Russell, Stewart, Vice Chairman Jernigan, Chairman Farmer.
Here.
Mr. Chairman, you have a quorum.
Okay, thanks so much. Members, anything need to start out with? Any comments or anyone like to recognize? Any personal orders, I guess, would be an easier thing to say. All right, seeing none, I have a couple of announcements to begin with. Folks and members, item 2, House Bill 1768 by Chair Lady Hazelwood is going to be rolled for 2 weeks. So without objection, House Bill 1768, item number 2 by Chair Lady Hazelwood is going to be rolled 2 weeks. And then moving down to item number 9, that's House Bill 1962 by Chairman Curcio. That's been requested to be rolled for 1 week. So to any objection with House Bill 1962, item 9, Chairman Curcio being rolled for 1 week? Seeing none, roll for 1 week. And that brings us to the beginning of the calendar. We have item 1 is House Bill 1735 by Representative Todd. But what we're going to do here, since we have testimony on that, I'm going to roll that to the Hill, okay? Because that's going to take some time, and we want to be courteous of other members to get in and get out when they get other bills running. So, members, without objection, I want to roll item 1, or I ask that we roll item 1, House Bill 1735 by Representative Todd to the Hill. Seeing no objection. Very good. And that's going to bring us to item 3. But if members, if you don't mind, if we could take item 4 out of order by Chairman Doggett. He's standing back there. I believe Representative Rudd is in another committee. So without objection, let's roll Representative Rudd one space, bringing us to item 4 to start the day. So without objection. So this is House Bill 2575 by Chairman Doggett. Sir, you have a motion and a second, and you're properly recognized.
Thank you, Mr. Chairman and members of the committee. What we are doing, it is in regards to anonymous reporting in cases of child abuse and neglect. In summary, the bill states that juvenile court cannot order parents or guardians to allow DCS to enter for the purposes of interview, examination, and investigation unless the department has presented evidence corroborating the anonymous report of harm.
Members, any question for the chairman? Seeing none, looks like we're ready to vote to send House Bill 2575 to calendar and rules. All in favor say aye. Aye. Opposed say no. No. Ayes have it. Bill moves on.
Thank you very much.
Thank you, sir. That brings us to item 3, and I'm being told that Representative Rudd is walking this direction, so let's give him just a few moments to get here. And Representative Rudd, welcome, sir. I was holding your space here for House Bill 1919. You're welcome. Members, we have a motion and a second. Motion. And you've got a motion and a second, sir. And I know you just came from another committee, so if you need a moment to. I handed the gavel over to Chairman Crawford. He's running my committee. Uh-oh. Oh, he is, yes. Yeah.
I have a amendment from sub 015176 I'd like to attach.
Okay. Got a motion and a second, so that is to adopt House Amendment 15176 to House Bill 1919. All those in favor say aye. Well, actually, let's back that up. Does it make the bill, sir?
Yes, it does.
Okay. You want to go ahead and explain it then?
Okay.
Or members, we want to get it on the bill, or let's go ahead and get it on the bill since it makes it. That's fine. So you've got a motion and a second on it. So all those in favor of adopting House Amendment 15176 to House Bill 1919 say aye. Aye. Opposed say no. Okay. Now we're on the bill as amended.
All right, thank you, Mr. Chairman and Committee. This is an answer to a problem that was landed in our lap that we didn't ask for, that the situation of unaccompanied migrant children. Been working on this for the last 6 months, and we've amended it and worked on it and did everything we can to get it in a good legal position, a good sound position. As you know, we can't tell the federal government in most instances what to do, but we can control what happens to the children once they're in the state. And what the federal government is doing in their child placement agencies and services that they use is they're putting them in facilities like they did in Chattanooga, and they're also placing them in individual homes. And we don't know when they're in the state unless something happens and that's reported to the state. So what this bill would simply do, without interfering in any other foster children or transportation or children or other children in their care or supervision, what this would do is these unaccompanied migrant children, as defined in interstate pacts, what it would do is it would make them report to the State Department of Children's Services so that they could inspect the homes or the facilities and look after the children and build a database of where this is occurring. And that's what it does. I'm open to any questions.
Very good. Members, just so everyone knows, I do have the Department of Children's Services on the list to come up to speak and answer any questions that anyone may have. With that said, Representative Harris, you had your hand up. Do you have any questions for the sponsor?
Thank you, Mr. Chairman. So I know we spoke about this before in the subcommittee, but based off of the way your language is written, it would create a Class E felony for anyone who continues to have a child in their care who the state does not know about, correct?
That would be correct. These unaccompanied migrant children.
And with that, because they were placed in those homes by the federal government, will this Class E felony have anything to do with the federal government in any kind of way? Will this be a penalty on the federal government?
No, the way it's designed is, again, we can't outlaw this procedure. This is for people that are in Tennessee who are housing. Now, if it happens to be, I don't know, let's say they place the child in an employee of the federal government, not in their official position where they're being paid, but if they happen to be a federal employee that lives in Tennessee, a citizen of Tennessee, they still have to report that to the state, or else they would be committing a felony. But as far as the federal government itself, no, they would not be committing a felony.
Representative Harris.
And as far as with DCS, the DCS would have to go into the homes, inspect the homes. So if, for instance, somebody just says, "Oh, I think I saw a unaccompanied minor in somebody's home," that notice would instantly make them have to go out and inspect that person's home, not once, not twice, about two or three times. Do you believe that DCS will have the bandwidth to go in and inspect homes randomly without true knowledge of whether they truly have an unaccompanied minor in that home?
Representative Ruff.
Yes, yes, they do, and they also have that now. If I were to call and say that a child, my next door neighbor is, I suspect that a child is being abused or in some way in danger due to their environment or where they're being physically treated, they would show up and investigate that now.
Thank you. Yeah. Any follow-up?
Thank you.
Members, any other questions for the sponsor? Well, I'm going to, excuse me, Representative Clemens, I understand you have a comment or question.
Question.
You're recognized.
Thank you, Mr. Chairman. One question I have on page 2 of the amendment that makes the bill, I believe, in section 1, subsection C, regarding the information that's stored in the database. It says it must be maintained as confidential, except that the department shall provide access to the database to law enforcement and other individuals and entities. Who are those other individuals and entities to whom that information would be shared?
You're recognized, sir.
The other entities, what would normally happen now is because, as you know, the DCS does not arrest or prosecute people like they would if it was an abused child that is a resident of Tennessee. They would report that to the police department, sheriff's department, and then it would go to the DA. So all, whether it be the TBI, FBI, local sheriff of police, or the DA, they would report that to those entities so the case could be investigated and determine whether it should be prosecuted.
Any follow-up?
Yes.
You're recognized.
Thank you, Mr. Chairman. Well, that's all included within law enforcement, so I'm curious as to the other individuals and entities. And then it allows it to be deemed appropriate by the department by rule. And so there's some unforeseen rulemaking as to what may or may happen and who may that be opened up to via the administrative rules-making process. So that information being provided to other entities is, I guess, my question and one of my concerns.
Chairman
if you can shed light on that.
I still think I've answered the question. Any entity needed in the prosecution and investigation, it would happen. And we had, in one of the many amendments and changes to the bill and working with DCS over the last few months, we originally had in there a more detailed description of making rules and forms, and they indicated to me in meetings that they feel they already have a lot of rules in place that will cover this, so we may change that to shall, so it would simplify that process for them.
Thank you.
Representative Stewart, you're recognized.
I was looking on the website. I didn't see a change to the fiscal note. Has the fiscal note changed the amendment?
This particular fiscal note we have here is what the fiscal note we had in subcommittee.
So there is an incarceration amount under the
Yes,
fiscal note.
oh, you had asked me in subcommittee, which I did meet with fiscal and asked, because we had like, I believe it was at 874 in and out, and then 12,100 for incarceration. The in and out is for DCS to pay another government entity within the state government to create the website and the secure site and database. So it all stays within state government. It's just one agency paying the other. I question the cost of setting up the database, but that's why that is even. The 12,100 is even indicates with fiscal that they don't expect a lot of incarcerations, but that's what that's for.
Okay, so that the $12,000 incarceration remains on a bill as we sit here.
Yes.
Okay, thank you.
Very good. And Representative Harris, I have you next.
And I had a quick question, Chairman. And so I'm originally from South Arkansas, so I don't think the last time I actually gave anyone my fingerprint was probably when I was a little kid. I don't think the state of Tennessee has a copy of my fingerprint. How feasible do you think that's going to be to get within 72 hours for us to file that?
Chairman Rudd.
I'm trying to see where you're addressing that.
Name, sex,
C?
height, and weight.
Section 1C?
Yes, that's correct.
Okay.
The 1A, item 5.
Well, it is the individual's responsibility within the 72 hours of taking on this responsibility to report to the state that they're going to be doing it, and they're supposed to get with the state either at the county level or state level so that they can fill out these their name, sex, height, weight, and everything, both the child and the individual. But this isn't about an arrest at this point. This is so they can register both the child and themselves if they're going to be housing or taking care of these children. So it would be upon the individual signing up and letting the state know they're going to be taking care of the child is when they do this.
So upon the start of that process, it doesn't have to be within 72 hours that this has to be completed. It just needs to be started within 72 hours, correct?
Yeah, the bill states, and C, within 72 hours of a child as described in Section A entering the foster home. So before that, or within 72 hours after, they should do it beforehand. Once they learn of the law, they'll be pre-registered to do this. But once they do take it, they're supposed to tell them within 72 hours because a child can be abused in that 72-hour period, so we need to know as quick as possible.
All right, thank you.
Very good. And members, I don't have anyone else on the list for questions for our sponsor. I believe no questions from Representative Gillespie. So, members, without objection, we'll go out of session. We'll hear from DCS. They've asked to speak on this. So, without objection, we'll go out of session to hear from the Department of Children's Services. And I believe you gentlemen know the drill. If you would, take a seat, be sure your microphone's on, and introduce yourself, who you're with, and then we'll keep that to 3 minutes, and we'll have plenty of time for questions and comments after that time's over. So.
Thank you, Chairman and members of the committee. My name is Jim Lehman. I'm with the Department of Children's Services, and I have Doug Diamond with me, who is our, our General Counsel. The department is flagged on this amendment. Want to commend the sponsor at the subcommittee level. We were working with sponsor extensively on this piece of legislation and want to thank him for addressing the majority of our concerns with the original bill as filed. The original bill was, I think, a little bit looser and would have penalized, more activity than was originally the intent of the bill. The reason we are having concerns with this amendment, number 15176, is just 8 or 9 words in section 3 of the bill in subsection 1 that puts individuals into the same sort of category as licensed agencies. So if you read section 3, subsection 1 on page 3, where it says it's the duty of the department to inspect at regular intervals without previous notice all child care agencies, that's in the law now. What's new is including but not limited to individuals suspected of violating 375407, which is this new notification requirement. The department is okay. We have no concerns with this new notification requirement in the bill to say, hey, let DCS know when these children enter into the state and that kind of thing, and it's a criminal penalty if you don't. What's concerning is putting individuals on, putting them into our licensure law in this way. So if an individual was accused of housing one of these unaccompanied minors, they were just suspected of violating this notification law, then we would be required to come out and inspect them at regular intervals, even if they didn't actually violate the law. Let's say they did not have a child with them, or they did notify us. The bill as written would require us to continue to inspect them at regular intervals, which for us is a square peg in a round hole. It doesn't make sense that we would treat them like we would a residential child care agency that has an ongoing license that we continue to inspect at regular intervals. So those are our concerns with the bill. I'll let Doug follow up if there's anything I missed.
Mr. Diamond, any follow-up?
Good afternoon. I'm Doug Diamond. I'm General Counsel for DCS. I think that Jim summed up pretty well our issues with the bill. It puts us in the position of really investigating a crime, which is violating the first section of the bill. We're not law enforcement. There's nothing in this. Nothing there is really abuse or neglect necessarily. So somebody who violated the first section of the bill by taking into their home perhaps an undocumented child who'd made their way to Tennessee across state lines, that might violate that first section of the act. But that's a violation of law. That's a crime. And we're not equipped to inspect or to investigate criminal acts. We investigate acts of child abuse. Now, if that same home if there was a violation and there was also an accusation of abuse or neglect, of course. But to just say, well, somebody violated the law, call in the Department of Children's Services, unless the law is one that is of child abuse or neglect and we're called in on that side, doesn't make any. It's not good for probably good for us. We're probably not good at doing that, frankly. We're not a law enforcement agency. So that's our issue. The bill is otherwise unobjectionable.
Members, do we have any questions for the department? We have Chairman Kersey on the list. You're recognized, sir.
Thank you, Mr. Chairman, and thank you all for being here today. When I first looked at this, I'm, obviously in favor of keeping children safe, and I know you all are as well. I know the sponsor has good intent, and so I took a long, hard look at this. But I want to make sure that I just heard you correctly. So, the scenario being, if my child is at Representative Garrett's house for the weekend, spending the night because he's hanging out with his kids, and a neighbor just sees a child they haven't seen before, and they suspect that he's harboring an undocumented child or a child from out of state or what have you, then if they call you guys to report a suspected violation because he didn't report, then you've got to go inspect his private home, and you got to keep. Did you understand to say you got to keep doing that? I just want to make sure I heard you correctly.
Yes, thank you, Chairman Kersey. That is how we read this statute. It says it's the duty of the department through its agents to inspect at regular intervals without previous notice all child care agencies or suspected child care agencies, including but not limited to individuals suspected of violating 375407, which is this new notification requirement.
Chairman Kersey.
Thank you, Mr. Chairman. So in that scenario, it's not abuse or neglect or anything like that. It may just be that Representative Garrett in this scenario didn't report that he had an unaccompanied minor. And so it's not that he hurt the child or anything else, which again is not what I'm getting at. I'm saying, what if he didn't do it? What if he doesn't have an unaccompanied minor? He just has my kid, who's over there spending the night with his kid. Then is there a cutoff there once you guys deem that he's not doing that? Do you get to stop inspecting his house? You have to keep going.
I mean, as General Counsel, I'm Doug Diamond again. Do you want? I would advise us not to under those kinds of situations. That we don't want the law to be an absurdity, but we would nonetheless be called in to. And I forget which of you is the bad guy in this scenario.
We're both good. We're both good guys in the scenario. Actually, yeah. That's right. Yeah.
Either way, we would be called in to investigate a suspected crime.
Right.
And we're not good at that. We're not the appropriate agency to do that. People should investigate suspected crimes, but that's probably a law enforcement function, not a child welfare function. Okay. We're here to protect kids.
Thank you. And I want to be. I don't know that that's the. I don't think that's the sponsor's intent. I think the intention is we want to keep kids safe and we want to make sure we know who's coming into the state and so forth. But I also know that the devil's in the details, and we want to make sure we get the details right. So thank you very much, Mr. Chairman. Appreciate your indulgence, and my compliments to my colleague.
Yes. And I think the thing is, though, you say you don't investigate crime, but I think when you come into an abuse situation and you find abuse, that you take those notes and you turn that over to law enforcement agencies. So I think the department does and is already involved in that process. Is that a fair statement?
That's a very fair statement.
Okay. Next on the list, I have Representative Garrett. You're recognized.
Well, Chairman Curcio actually took my scenario, and then Chairman Farmer just asked my follow-up question on one, if what your investigations and what the powers of the DCS, what your powers of investigation are. If you find a particular situation under this legislation, wouldn't you refer that to a DA to then bring charges? You're not a district attorney. You're not someone that has the ability to charge someone. You've kind of coming in on the back end when the abuse allegations are already known. Then you are investigating something that's within your wheelhouse regarding child abuse. It seems like this is the cart before the horse scenario, where you don't know what's going on and you don't know what you're coming into potentially under this legislation, like the scenario that Chairman Curcio brought. Is that where your concern is that this isn't really what you do?
Mr. Diamond?
Sort of.
Okay. Well, clear me up.
Okay. We may be in at the front end. Certainly a criminal investigation could come out of an allegation of abuse or neglect, which is what you're getting to, Mr. Chairman. But we don't follow up from there on the criminal side, and we wouldn't be investigating for violations of law. We're investigating for abuse or neglect of children, which can independently constitute violations of law. The two are closely intertwined in a number of our cases. In this case, though, this is a pretty broadly cast net and could involve us investigations that are purely accusations of criminality, i.e., bringing a child into the state and not reporting to the department and under the trafficking laws, which is what this is here, but not involve any abuse or neglect at all of the child. So if simply the allegation is somebody has brought a child in to the state, into their family home, and not reported as they should according to this bill, that could be reported but to law enforcement, because if there's no independent allegation of abuse or neglect of a child, we're not the appropriate agency to take that report. And we don't, I'm sorry, I didn't mean to interrupt.
No,
we barely have the resources to keep up with. We get something like 150,000 or something calls to our hotline already every year, and we are strained already pretty hard.
Representative Garrett, any follow-up you may have?
Thank you. Yes, you somewhat answered my final question, is what is under the purview for you then to investigate. I believe you said that in a neglect or abuse situation. So right. In other words, this is going to expand that scope, and what I'm hearing is you may not have, if this even becomes law, you may not even have the capability of doing what the law says you're going to do without hiring a lot of folks. Is that a fair
I don't
statement?
know.
Mr. Diamond, you're recognized, sir.
I'm sorry. Do you want me to announce myself every time?
You do not have to.
Okay. Thank you. I think you've got it.
Okay.
Yeah, I think that's pretty much it.
Thank you very much for clarifying that, Mr. Chairman. Thank you.
Very good. Members, I have next on the list, I have Representative Clemens, sir. He waves off. Anybody else? Representative Bricken, you're recognized, sir.
Thank you, Mr. Chairman. Just kind of an operational question. I like to get a best definition of what an interval cycle would be. And second, the number of possible illegal aliens that's being housed in Tennessee today, would they automatically come under this bill and have to be start reporting, or it's just for newcomers coming in?
Right. Mr. Diamond, or
I know I handled the first part of that question, and we have our director of licensure here if I say something incorrect, but for our licensed agencies, which again, this is, inserting individuals into the area of the law about licensed agencies inspection, I believe our regular intervals that we check in at is twice a year. And then the second part of the question, Doug, did you?
I think you're asking would the law apply just prospectively?
Correct.
And I think, as I read it, that's a great question. We hadn't thought about that, but it looks to me like it would operate prospectively, yes. I don't see how we could apply it against somebody.
I don't know.
After the fact.
I guess
right.
we could legislate it.
No, I don't think so.
You know how many individual homes possibly would come under this umbrella?
Well, according to federal data reports, there were about, I think it was 4,200 and change sponsor homes in Tennessee in the federal fiscal year 2021, and there have been about 1,500 or 1,600 homes since then up through January. So a chunk.
Yeah. Representative Briggen, any follow-up to that?
No, thank you.
And I just a quick question: can we anticipate another 3,500 or 4,000 more this year, or?
I see no reason not to.
Right.
I mean, that's the data trend. If you go back a few years, they were down 15. It goes up since the federal figures start in like 2015 in the chart that I've seen, and it's a pretty pronounced upward swing. Yeah.
Okay. Chairman Russell, you recognize.
Thank you, Chairman, and thank you all for being here. Have y'all had any cases involving undocumented children?
I'm sure we have.
Do you mean cases of abuse and neglect?
Yes. Would you have any numbers, stats, or anything like that?
We do not.
Could we get those, or is that something y'all don't keep track of?
We do not keep track that I'm aware of for that. I'm not going to say we don't. That's not an area of my expertise. We can certainly take a look and get back to you with that.
I'm happy to look into that.
Thank you.
Sure.
Yeah, if you guys could find, if you have that information, if it's available, if it's not confidential by any law, then we'd appreciate having it.
Sure.
Thank you. Members, any additional questions or follow-up? Chair Lady Littleton, you recognize, ma'am.
I have just one question. What about the ones in Chattanooga? Did you guys not go there to the refugees? Okay.
Yes, thank you, Chair Lady. Yes, so that was a licensed facility, and so we did inspect, and we would have gone in for the allegations of abuse and neglect, and then also inspected that facility at regular intervals as well. Am I getting that right, Doug?
Yep.
Yep.
Thank you.
I don't think so. No, thank you.
No, thank you, Chairman.
Very good. All right. Without objection, we're going to thank you both for being here, and we'll go back in session. Without objection. All right, Representative Rudd, we're back in session and on the bill as amended. So.
Thank you. First, I want to address one thing you said. I think they're being very misleading as far as the legislation. If I wanted to, of course, you could be charged for that crime too under current state law. But I could call up Mr. Curcio's neighbor and accuse his own kids of being abused if I wanted to harass them. So calling up, I don't think there's going to be wholesale calling up because that's already a violation. That would be a separate crime already under Tennessee law to make false statements just to harass someone. As far as the Chattanooga facility, at that time the state did not know that facility existed. The federal government did not tell anyone. They did not know those children were there until abuse was reported. Then they went and investigated. I have tried my best to work with them. The one thing they've wanted removed all along is investigating single-family homes and investigating unlicensed providers. Well, the whole point is, if we rip that out, as legal told us in numerous meetings of their legal counsel, if we rip that out of the bill, there is no bill, because that's how the federal government is housing children in the state now, as in individual homes so they can hide them. They're no longer renting large facilities like they did in Chattanooga. And there's thousands of kids going through the states, hundreds of kids being housed in Tennessee. We usually don't find out about how many till after the fact because it's in the budget. So we still don't know where the children are being housed. We don't know if they're being abused. In many states, as in Chattanooga, they were being sexually abused. And we need to put a stop to this, and we need to track it and build a database. And it's not practical. If we take single-family investigations out, there's nothing to investigate because that's where they're being housed, and someone has to have the responsibility. I had a conversation with a representative from DCS last week, and just point blank told me that we are not an investigative agency. And I said, well, what do you do when you investigate children that in licensed facilities or children next door? So, well, we go out and investigate. I said, therefore, you are an investigative facility. He said, well, we don't prosecute or we don't arrest. I said, we're not asking you that you would report it to the legal authorities for them to take over the investigation at that point. And if they find a home that is not, nowhere in the legislation does it say if they go out and investigate a home and there's no wrongdoing there that they have to continue to investigate the home. That's just not there. There's no other agency that is equipped to determine if a child is being abused than DCS, and then they would hand it over to legal authorities, and that's what the bill does. I don't know of any other remedy to handle this, that there are children being transported across from the border, across state lines and in the state, and we don't know if they're being abused or not. We may not be able to outlaw the federal government from doing this, but we can keep track of them. Point blank, the DCS representative told me, after arguing about this, and he said, we do not want to do this. And, well, that's what we're here for. We don't take their orders, they take ours. There's no other agency that is equipped or prepared to handle this but them. If it's determined that they don't have the resources, next year they can ask for more money. But in this original amendment, they didn't tell fiscal they needed more staff. I tried to work out an additional amendment where we more clearly define the responsibilities, and they came back with a large fiscal note on the new amendment that I didn't run. So I'm running the amendment that they agreed to with the exception of investigating single-family homes. And again, that's where they're being housed. If we don't investigate that, we're just going to allow this practice to continue.
Thank you, Mr. Chairman. I just want to get back to something you said, and I want to get this clear. Are you saying that the state of Tennessee did not license that Chattanooga facility?
Chairman Rudd, you recognize.
It may be licensed now. It may be that the agency was licensed out of Georgia, but the state did not know they were there. No one knew they were there. It was a shock to the administration, according to news reports and according to reports to this legislative body and to representatives and senators in Hamilton County, that they did not know the children were there.
So if there are reports that the state of Tennessee or an agency thereof licensed that facility prior to the reports of abuse at that facility, would you disagree with that?
If I can't disagree with something I don't know, but I can say this. When it was reported in the press and that children were being housed there, no one in the state admitted to knowing. And then once it was reported that it was investigated and determined that children were being abused. And at that point, the facility was shut down. So if the state did know, if the facility was licensed, then apparently someone was not properly investigating it, or the abuse happened between investigations or tours. Either way, at the time, the governor's office said they didn't know. The mayor and officials in Chattanooga said they didn't know. Elected representatives and senators didn't know that former fraternity, I believe it's a fraternity building that was no longer in use, was being used for this.
Okay, thank you, Mr. Chairman.
You're recognized. Go ahead.
Thank you. I just want to make sure the record's clear. I think it would be a misrepresentation to say that the state of Tennessee did not license that facility, just based on what I've read. So thank you, Mr. Chairman.
And I just let members know I'm letting folks go back and forth. Everybody's been very cordial and professional. As long as it stays that way, I'm not going to recognize each time. So next on the list, I have Chairman Russell, I believe.
Thank you, Mr. Chairman. And Chairman, thank you for bringing this legislation. If I'm not mistaken, DCS licenses orphanages and DHS licenses the child daycare centers. Have you compared the two databases to see which would be better to house these collections and documents and everything?
Well, I can't investigate their databases. They're privileged. I can't view those.
Okay, I was hearing you say a while ago that no other agency would be equipped to handle this, and I was thinking DHS, you might have looked into that too.
Well, I think the reason why legal chose DHS, and they've never complained about this process except single homes about investigating, is because when it comes to investigating child abuse, when it comes to investigating facilities and people licensed, that's what they do. And whether it be a large facility like a hotel or a dormitory or a fraternity or a large home, like in Chattanooga, or individual homes, they're the ones that would normally address this.
So I agree. I was thinking, DCS is really good at looking in child abuse cases where DHS may be better at looking at license issues. So that's all I got for that. Thank you.
Well, I think part of it, Mr. Chairman, I think part of it is as they said, they don't want to investigate unlicensed facilities. They only want to investigate licensed facilities. The thing is, the federal government, their subcontractor may not be licensing everything, and we want to make sure they're licensed, because if everybody is, it could very well be that it is a federal subcontractor or out-of-state agency that is contracting all of these individual homes. And it's not the individual homeowner themselves, but they're working for someone, so that company would need to be licensed by the state, and that's what we're wanting them to do. We're wanting everyone responsible for this to report to DCS, and if there's an agency or a company doing this, we want them to be licensed or at least supervised by the department.
So I agree with what you're trying to do. The federal government sending all these kids here and they're bussed off to who knows where. However, I think we're dealing with two different issues. We're dealing with child abuse investigations and licensing, and I just personally think that DHS would be better to support the licensing part of it. So that's my 2 cents. Thank you.
Very good. Any follow-up?
I think it'd be creating an even larger bureaucracy if we have two state departments doing two different things in this. They'd have to coordinate. It'd be better to have one in charge of it. And if it ends up that one department who is best qualified, which is DCS, that we would pay whatever we need to pay to make sure this problem is taken care of.
Hey, I have one question, Representative Rudd, or Chairman Rudd, sorry. What do we know if once these children are placed where they are? I mean, these kids, they didn't cause this. It's from the irresponsibility of our federal government. That's why these kids are here. Without their parents, who knows where they are. But do we know is anyone checking on them once they get placed in these homes? I mean, who's looking after them? Who's making sure they're not abused? I mean, do you have any idea with regards to that?
As far as I know, both here and elsewhere, no one's checking on them unless states pass this type of law and create this. Other states have tried to outlaw the federal government from doing this. Of course, we can't do that. We found that out during the pandemic. There's just certain limits we have, what we can tell the federal government to do and not to do. This is the best simple solution. It's actually a very simple solution to take care of that. We do know that the way these children, the journey happens is, in most cases, parents from, let's just say as an example, Guatemala, Honduras, El Salvador, Central America, either due to political, economic, or crime, they want to get their child out into the United States. And they pay, in most cases, what's called mules and drug dealers to maybe $5,000 to get their child across the border and then turn them in to the Border Patrol and to the federal government. At that point, they transport the children across the country to different states where they're housed. And beyond that, they usually stay here sometimes for a few nights, sometimes for a few weeks or months. We don't know. We do know there are reports that have been reported that many of these children, not all, but many of these children do end up in their relatives' hands eventually, or the child's custody is used as a way for their parents to come here more easily. Some of these end up in sweatshops, some of them end up adopted, some end up in sex operations where they're abused. So it's like most migrant or immigrant children as well that are here, they can be taken, as well as adults, can be taken advantage of during this whole process.
And thank you for that. Next on the list, I have Representative Garrett. You're recognized, sir.
Thank you, Mr. Chairman. Thank you, Chairman Rudd, for bringing this legislation. I think the intent of what you're trying to do. I think what Chairman Farmer asked is we need to know, from the state's perspective, we need to know if these kids are here. And I think that's somewhat, or at least partly, what your bill's going to do. We will know that it's here because there's a reporting system. But here is my hard time reconciling what I think is happening, is that the department already they have 150,000 complaints they have to respond to, right? Right now, DCS doesn't have enough staff just to respond to their current issues that our kids are having here that we know about, right? Regardless of the ones that we don't know about. And I don't even want to fathom which ones don't get reported. Of the 150,000 they respond to, I bet there's twice that many out there that kids are being abused that they just don't report, right? I wish we had triple the amount of folks that could respond to these complaints, or the 150,000 that's out there. I have a hard enough time in my own office responding to enough complaints that we get representing the 45th District. So my concern is, how do we reconcile that? How do we force the department under this statute to do something that they're saying there's no solution to abide by the statute? What do you recommend they do in that regard when they're telling you by their testimony here, we can't do this? We don't have the ability. There's no way we can. There's a fiscal note, but there's no way to do this, probably if it was funded, in order to respond to keep up with this. What do you suggest they do in order to meet the needs if this statute should become law?
Well, there's several parts to this question. Number one, this fiscal note is from, it's about 2 weeks old. They provided the information to fiscal review, and they said they didn't need any additional staff. They only needed $874,000 to build a database, which really cost probably $2,500. Because I used to be on software support and database management, so I know what it's cost. You can copy one over the other, change it, and change the input screen and make sure it's secure. But I'm sure that goes on in multiple departments, and it's all staying within state government. I think that as far as the cost, they didn't indicate that they didn't have the staff under this current amendment a week or two ago. After they told me, after they raised their voice to me and got angry at me saying they didn't want to do this, they didn't want this responsibility, suddenly they don't have the staff. So I'm not sure what to believe. I have worked with them for almost 6 months. I've been truthful with them. I've made changes to the bill. The last remaining change they want to bill would gut the bill, and they wouldn't have anything to do, and the children would still be coming in out of the state. And I don't want something to pass legislation just to go on a palm card for my reelection. I want to solve this problem, and I think this is the only way. Now, if they end up actually needing more staff, or it be 5 more inspectors or investigators or 20 more, then I think it's our responsibility to give it to them down the road. But as of right now, with this amendment, they didn't ask for additional staff.
Any follow-up?
No, thank you. Thank you, Chairman Rudd.
Very good. Members, I don't have anyone else on my list. Anybody? Questions? Questions been called? Any objection? Seeing none, looks like we're ready to vote to send House Bill 1919 as amended to Finance. All those in favor say aye. Aye. Opposed, say no. No. Sir, bill fails. And that brings us to item 5. Representative Beck is somewhere. Oh, there he is. There he is. There he is. House Bill 2284. Sir, and you've got a motion and a second. You're properly recognized. And
thank you, Mr. Chairman. It's horrible what drugs have done to our society. It's even affecting how property is inherited. Right now, under the code, there is a presumption that anyone who does a will has capacity. Well, that's not necessarily the case, especially when you're addicted to drugs. This particular bill is going to change the presumption of capacity in the last 30 days if you kill yourself by suicide. And it's a holographic will. In other words, you write it right before you kill yourself. What has become apparent is people get depressed. They get isolated, they run their family off, and a lot of times it's a suicide note that has been introduced as a will, and right now the presumption under the law is that person who is about to kill themselves has the capacity to do that. So what I'm asking the committee and what this bill does is in those last 30 days, if you kill yourself, now if you die of natural causes, of course, this does not come into play. So with that, Mr. Chairman, I stand to take questions.
Very good. And I already have a taker. Representative Garrett, you're recognized, sir.
Thank you, Mr. Chairman, and Representative Beck. Thank you for coming to me on the floor sometime and talking to me about this legislation. I think it's really good. I mean, me and you both practice in the probate world. Although I don't believe I have a particular situation that meets this, I have had several holographic wills, and they tend to be disputed for many different reasons. And this has some real implications on those last days of someone's life that might have a mental condition of someone that's unduly influenced a particular person, that all of a sudden that person gets everything that they own and their minor children get nothing. And so this is a protection for that. So I do appreciate you bringing the legislation and recognizing that someone under those circumstances may not have the mental capacity to realize what they're doing with their bounty, with their children, with their family, with et cetera. So I really appreciate you bringing this legislation. I'm glad to support it. Thank you.
Any follow-up, sir?
Yes, thank you, Chairman Garrett. This is I had this exact case where the daughter came to us and her father had killed himself and left everything to his latest girlfriend, and we can't use props, so I can't. Would have shown you the will, which was a suicide note, and the girlfriend had it that suicide note probated.
Wow.
So that's what this is. That's what this is geared to stop.
And I have next. I have Representative Bricken and then Chairman Curcio.
Just a quick question. It's just kind of a quick observation. Should this have leave with the definition of 1 month, or should it actually have a number of specified days? Because how do you define a month?
That's a good question. You're recognized, Representative Beck.
Does it not say 30 days?
Well, I don't know. I'm looking at maybe it's in the detail of the bill. I was just looking at my.
It's 30 days from the date of, counting back from the date of the suicide.
Maybe I was looking at the summary of the bill that said a month, and that's what was throwing me off. So.
Thank you, sir.
Chairman Curcio,
it does say
you recognized?
Thank you, Mr. Chairman. I apologize. I didn't want to jump in, but that actually was my question as well. I've got it up in dashboard, and I think this is a great bill. It does, however, say 1 month prior to a testator's death, and the testator died by suicide.
Correct.
So it doesn't say a number of days. I don't know if you feel it's important enough to make that change. I don't know if we have the opportunity to do that or not. But
I don't think it's a substantive change. I think we could just make a verbal amendment, which we typically wouldn't if it's a substantive change. But a month, 30 days, I think we all can agree that's, I think.
And then I do have a follow-up question, though. Before we realize that issue, my question was and again, I think this is a great idea. How'd you come up with a month? I mean, I've unfortunately had family members just like everybody else who've dealt with drug abuse issues and unfortunately death and suicide. But did you just, in your experience, a month would get it, or you just had to pick a number?
I had to pick a number, but also if they fall into this depression and this spiraling down of drugs, et cetera, it's usually goes back several months. So a month, it's not like typically you're not going to spiral down within 30 days. It's going to be longer than that. But we wanted to cut it off at the 30 days, and I do want to come back and make a verbal amendment for the 30 days.
Well, thank you very much. Thank you for the bill. I think it's a very creative way to solve this issue, and I can't believe somebody probated a suicide note, but then again, I could see how it could happen. So thank you.
Exactly right. Thank you.
Representative Garrett, you're recognized, sir.
I was just going to make a motion to replace 1 month with 30 days if it's okay with the committee. So I was going to make that motion. Since it's not substantive, it simply corrects the intent of the legislation.
Correct.
And I think 30 days defines the appropriate time frame that the sponsor wants. So with that, Mr. Chairman, I move to replace the language. If it needs to figure out exactly what it needs to be, I would refer to legal. But within 30 days of the testator's death.
So as I understand it, Section 1, subsection B there, it says upon the contest of a holographic will if the holographic will was written within 1 month prior to a testator's death and a testator died by suicide, what we're going to do, we're going to take that 1 month and we're going to replace that with 30 days, 30 days, 30 days. And we'll spell it out. Very good. Any objection? We've got a motion and a second. So without objection, we're going to take that as verbal amendment 1 and we'll adopt that to House Bill 2284.
And Mr. Chairman, I consider that a friendly amendment. I appreciate Chairman Bricken bringing that to our attention because those 2 days could mean a big difference. I mean, from 28 to 31. So I appreciate that. Thank you.
Very good. Members, we got a motion. It's been explained. Anybody have any questions before we vote on it? To adopt this verbal amendment 1 to House Bill 2284. All those in favor say aye. Aye. Opposed, say no. Ayes have it. So we're back on the bill as amended. Members have any additional questions for Representative Beck? Question's been called. Any objection? Seeing none, looks like we're ready to vote to send House Bill 2284 as amended to calendar and rules. All those in favor say aye. Aye. Opposed, say no. Ayes have it. Bill moves on.
Thank you, Mr. Chairman and committee.
Thank you. That brings us to item 6, and that's Representative Powell as he makes his way up here. House Bill 2756, and you've got a proper motion, proper second. And as you're gathering your items there, it looks like you have an amendment 015219. Is that something you'd like to move forward with?
Yes.
You got a motion and a second. Does that amendment make the bill?
It does. If I get that on, please.
Okay, members, let's go ahead and get that on for Representative Powell, and then we can talk about it. So, all those in favor of adopting House Amendment 15219 to House Bill 2756, say aye. Aye. Opposed, say no. Ayes have it. Back on the bill's amended. You recognize, sir.
Thank you, Chairman, members of the committee. So, this bill supports the original intent with the formation of juvenile courts by the General Assembly, streamlining the process further. As amended, it required the court in dependency cases to set a scheduling order and hearing in the initial appearance. The purpose of legislation is to make sure the court is moving the case through the court system promptly and providing a scheduling order which would make sure that the parties are able to get whatever they need to be ready for trial. As it says in the statute, one of the public purposes of the juvenile law is to provide a simple judicial procedure in which the parties assured a fair hearing. The bill as amended would add language to ensure that juvenile court cases are expeditiously moved through the system without unreasonable delay. The language was worked out with DCAT to be set within 6 months. A responding party, which is typically the parent accused of neglect or abuse, can waive the 6-month requirement, and in that case, the court will set their hearing within a year. This is similar to what the legislature has already done for termination of parental rights cases. And as I said, DCS has reviewed the language and is okay with this piece of legislation. And we have a combined goal of permanency for the children and protecting parents' rights, which are equally protected in this bill.
Very good. So I thank you for that explanation. The question's been called. So members, any objection to that? The question being called? Looks like we're ready to vote. Send House Bill 2756 as amended to calendar and rules. All those in favor say aye. Aye. Opposed, say no. Ayes have it. Bill moves on. Thank you. Next on our list, we have item 7, House Bill 2533 by Chairman Ramsey. And there he is. And you've got a motion and a second, a motion again. And he's going to need that because he has an amendment, 013796. So, head of the game there. Does that make the bill, sir?
Yes, sir. Thank you, Mr. Chairman.
I mean, is any objection on going and voting to adopt this amendment? Seeing none, all those in favor of adopting House Amendment 13796 to House Bill 2533, say aye. Aye. Opposed, say no. Ayes have it. Now, we're on the bills amended.
Okay. Thank you, Mr. Chairman, ladies and gentlemen. Tennessee has ranked in the last few years the top 2 or 3 states as far as regarding men murdering women, and the vast majority of these victims know their murderer. This bill, as amended, is a simple bill. It requires a sheriff, deputy sheriff, or constable prior to or at the time of serving someone with an order of protection or ex parte order of protection must make reasonable efforts to determine whether the person being served has an outstanding criminal warrant. In the case that they do have an outstanding criminal warrant, they will be required to either serve the criminal warrant or notify the agency holding the warrant of the person's location. This is a simple bill. It has no significant cost. The bill begins to address the breaks in our safety chain that allows us to protect our citizens from preventable domestic violence. Why do we need this bill? The bill addresses a highly publicized tragedy in which Marie Varsos and her mother, Debbie Seco, from Lebanon, Tennessee, were actually hunted down and brutally murdered by Marie's husband, Sean Varsos, in 2021, April. We are very privileged and have this distinct advantage of hearing the testimony of Debbie Seco's son, Alex, as to what, including the adjustment of our law, could have been done to prevent this tragedy. So with the will of the committee, I would like to go out of session and let Mr. Varsos, or pardon me, Mr. Seco, tell us his story.
All right, I do not have a request, sir. And I apologize. It's our policy and our rules. And I know I was in committee earlier when you told the story about losing your sister. So I'm sorry, your mother, sir. And he's not on the list. You did.
Yes.
Members, any objection to now?
Mr. Chairman, I make a motion we suspend the rules to allow this man to testify.
Very good. Members, any objection to that? Seeing none, all right, we're going to suspend the rules, and without objection, we'll go out of session and hear from this gentleman. Sir, if you would, go ahead and approach the mic.
Yes, no, thank y'all very much, and I appreciate the time.
And I apologize, I just try to follow the rules.
No, totally understand.
But, thank you for that motion, Chairman Curcio.
My name's Alex John, and I'm born and raised here in Nashville, Tennessee. And last April, my mother, Debbie Cisco, and my sister, Marie Varsos, were murdered by my brother-in-law. In the weeks prior, my sister was strangulated by my brother-in-law to the point where she eventually passed out. And when she awoke, she was held captive with a gun to her head, pleading for her life to be saved. Eventually, she was able to escape. And over the following 5 weeks until their homicide, my sister, my mother, and myself and the rest of our family did everything we could to navigate the very bureaucratic process domestic violence victims face every day here in Tennessee. We lived in a constant state of fear, not knowing where my brother-in-law was or what harm he could do to my sister or our family. After spending what seemed like a grueling hell, closing down all three of their affairs in the middle of a global pandemic, 2,000 miles nonetheless, I set about the process of trying to understand what, if anything, could have been done to save them. I wanted to make sure that no family had to endure what we had to go through. I reached out to a handful of agencies that my sister came in contact with, the same agencies that we turned to for help to understand what might have happened. Through that process, I put together a timeline to understand what happened as well as what could have done to prevent this tragedy. And that's what actually brings me here today. After my brother-in-law was notified by the Davidson County Sheriff's Office that an order of protection had been filed, he walked into the Davidson County Sheriff's Office to be served that order and then walked right back out the front door. You heard that right. He walked right into that office with 2 open warrants for his arrest, one for false imprisonment and the other for aggravated assault. The sheriff's department had not checked to see if he had any outstanding criminal warrants. It wasn't until 48 hours later, after my sister notified authorities of his whereabouts, that he was eventually arrested. Can you all imagine how empowered he felt? Walking in and out of a sheriff's office knowing that less than 24 hours before, he strangulated and held a gun to someone's head. I was shocked and stunned when I heard that this is what went down. It seems to me like this is a common sense thing to check and see if someone has outstanding warrants before they are served an order of protection. It could have allowed authorities to intervene earlier rather than enable my brother-in-law to do more harm. I ask and plead with you to help address these loopholes by supporting House Bill 2533. I realize that this won't bring my mother and sister back, but I hope that it will help save others, and I thank you all for your time.
And thank you for that. Members, do we have any questions or comments for our speaker? Representative Parkinson, you're recognized, sir.
Thank you, sir, and thank you. You know, it's absolutely horrible what you've gone through and your family has gone through. I want to commend you for the courage to even build up enough to even come here and tell that story and tell your story and relive it again before all of us, man. So I'm grateful that you are turning this tragedy into something that can be helpful for a lot of other people that may be in the same situation. I you know, send my condolences to you and your family and empathize with you greatly. And I'm sorry that happened to your family.
Appreciate that. Thank you.
Members, any additional comments or questions for our guest speaker? All right, seeing none, and thank you so much for being here.
Thank you very much.
Thank you so much. And without objection, we're going to go back into session. And I have Representative Clemens. Did you have a question for our sponsor?
Thank you, Mr. Chairman. I just wanted to, following up on that courageous testimony, I just wanted to also thank the members of our committee and this body. Last year, some of you probably remember we had House Joint Resolution 430 and 431. Many of you on this committee actually co-sponsored that resolution honoring the life of Alex's mother and his sister. His mother was a great leader for working families and fighter, and his sister was a beautiful soul. And so I want to thank everybody up here for helping unanimously pass those joint resolutions, and thanks again.
I have Chairman Kersey on the list. I don't know who said that. If you don't mind to withdraw it, we'll get there. We're going to get there. Chairman Kershaw, you're recognized.
Thank you, Mr. Chairman. Excellent piece of legislation. Thank you for bringing this, Chairman Ramsey. But my question is there a unified database where will they be able to easily obtain this information where they can search it, or do they have to actually contact the neighboring municipalities or the other? And if you don't know, it's okay. I can find it off online. But
I'm not.
That's good. Good question. Yeah, you're recognized.
I'm not aware that kind of alteration would have to be made. I'm assuming that it's a matter of communication. We had a bill like this before where clerks transmitted to law enforcement orders of protection, and I assume that this is the same pathway that would be available. Well, one of you may be able to answer that better than I can.
Chairman Kershaw, any follow-up there?
Well, thank you, Mr. Chairman. And I guess because I think you've addressed it where you say make reasonable efforts to determine. I think if it said shall and there wasn't a unified database to find these things, then we might be tripping our law enforcement up. But I think reasonable accommodations probably takes care of it. But I just wanted to draw attention to that. I think it's an excellent bill. I'm happy to vote for it. But I just wanted to understand that logistical piece. So.
Any follow-up to that?
No, sir. I appreciate the indulgence of the committee to let Alex speak today.
Absolutely. Chairman Russell, you're recognized.
Thank you, Chairman. And just to clarify, the law enforcement officers, when I worked the road, we had two systems, NCIC and TCIC, and we can go through both of those to verify a warrant check on the suspect. Thank you.
Right, and I think the issue is we constables regularly serve these. So I guess the question is, do our constables have access to TCIS and NCIC? Chairman Russell?
Thank you, Chairman. If they are a member of the local law enforcement community, they've got access to the 911 center. 911 center can run it for them.
Okay. Very good. Thank you, Chairman Russell. Members, that brings us back to Representative Bricken. And the question has been called. All right, members, we're ready to vote to send House Bill 2533 as amended to calendar and rules. All those in favor say aye. Aye. Opposed say no. Ayes have it, and bill moves on.
Thank you, ladies and gentlemen.
Thank you. That brings us to item 8, House Bill 2359 by Representative Garrett. Second. You got a motion and a second. You're properly recognized, sir.
Thank you, Mr. Chairman. I don't believe I have an amendment. What this does is, in a conservatorship matter, the actual fiduciary, they usually have to provide an annual accounting. With that annual accounting or a statement that says the actual conservatorship is still needed, what this law says is they don't have to disclose that person's private medical information as required now. And so it just keeps their medical information private because a conservatorship matter is a public matter. So that's all this does. This bill is brought to me by the Tennessee Bar Association. So with that, I'll take any questions and I ask for passage.
Question has been called on the bill. Any objection? Seeing none, looks like we're ready to vote to send House Bill 2359 to calendar and rules. Sir, all those in favor say aye. Aye. Opposed, say no. Ayes have it. Bill moves on.
Thank you, Mr. Chairman and committee.
And that brings us back to our item 1, which we moved to the hill of the calendar. And thank you for your patience, Representative Todd, on this. I thought we'd get through those bills a little quicker. I misjudged Chairman Rudd's bill there. But House Bill 1735, sir. And you've got a motion and a second, and you're properly recognized on it. And I know you have an amendment that I believe we adopted last week.
That is correct, sir.
And that is House Amendment 13807. And you've got a motion on the amendment. Second. Okay. And there's a second. And I haven't had a chance to talk to you about this, but did you as I understand it, did you want to withdraw this amendment, or what was your?
Is the amendment currently on the bill?
The amendment is on the bill.
Okay, we'll leave it as is on the bill.
So it's your intent to run this as is?
Yes.
Okay, very good. All right, members, this bill has been amended. There is an amendment on it. So as I understand it, we won't need to vote that again because this came from last week. So you've got a motion and a second. You're properly recognized.
Thank you, sir. And what this does is this particular bill lowers the age for our citizens, our law-abiding citizens, to carry a handgun, lowers it from 21 to 18, and this puts us in the same position age-wise as the ability to vote and also serve in the military. And I know we have some folks here to testify today, and if you'll entertain that, I don't know how many or who, but I'm sure you've got the list. I just was aware that some were.
Right. I have 3 on the list. I have Toby Mayer, Garrett Floyd, and James Fry. So those are the 3 that gave our office notification to speak. Members, do we have any questions for Representative Todd before we gavel out of session and hear from those folks? Very good. So with that, members, any objection to going out of session? Seeing none. And I'll take, I guess it's Toby Mayer here. There he is. You've got 3 minutes to make sure your microphone's on and introduce yourself to the committee and
Thank you, Mr. Chairman. Question, can I yield my testimony in case it is needed for later, possibly?
No.
I cannot? All right. Well, anyway, thank you very much for the opportunity to speak. I'm going to be very short in that case. Basically, just my name is Toby Meyer. I'm with T-Rex Arms, and I'm an attorney. I support this bill. I think it addresses a bunch of important issues. One, Tennessee is one of very few, or Tennessee is one state that does not allow, there's other states, but Tennessee is one state that does not allow adult Americans to carry firearms up until they're 21. There are other states, for example, Indiana, that do allow states to carry firearms when people are 21. And it would be, in my opinion, just to allow people to do the same thing in Tennessee, specifically given that all of us males at least have to register with the Selective Service once we're 18, which means fight for this country, protect everybody in this room from Russia and China, and it would only be just to give people at that age also the right to defend their own lives. I think the bill right now addresses a bunch of concerns. So I think in the past, schools were brought up. So schools are still exempt. Other than that, it's covered by TCA Section 3917-1309. So people would not be allowed to carry on school property. I think that was a concern. With that, if there are any questions, I'm happy to answer them. I don't want to waste any more of your time. Thank you, though.
And just one point of clarification, with regards to your comment about school property, it's taken out with the amendment.
So Tennessee Code Annotated Section 3917-1309 still prohibits individuals.
what I meant by that is, let me recognize you before you speak. Let me go ahead and implement that policy back, and then let me tell you this. What I meant was that with this amendment, you would be able to carry on school property with a firearm.
That's not entirely correct. Yeah, thank you, Mr. Chair. My apologies. I missed.
Once again, I'll recognize you before you speak. Okay, just hang tight. Let me say this one more time. You would be able to store a weapon in a vehicle on school property if this amendment and this bill passes. So, but you're recognized. Go ahead. Any follow-up to that?
Yeah, thank you, Mr. Chair, and thank you for the clarification on the rules. My apologies, I misunderstood it as a question, and yeah, anyway, my apologies, but yeah, to address this, with the amendment on it would still be illegal to carry a firearm on school property. That is correct. It would be illegal to carry a firearm on school property.
Okay, thank you. And I have some other members on the list. I'm sorry to confuse you, just trying to keep some order here so we don't speak over one another. That helps everybody because we got not only people here in the audience watching this, there's people by video, live stream, who knows where. So that's a good thing. Transparency is good. Next, let's have Representative Gillespie. You're recognized.
Thank you, Mr. Chairman. Quick question. You mentioned earlier in your opening statements about specifically a firearm. Is this for all firearms, or is this specifically for pistols, handguns?
You're recognized, sir.
Thank you. It is for handguns.
Very good. Representative Gillespie, you're recognized.
Okay, that's kind of what I figured. When you mentioned some other states, I was a little confused there because I was also under the impression that for pistols or handguns, it's 24 or 21 years across the board. And you said earlier it was 18.
You recognize.
Thank you. So a person under 21 can currently not purchase a handgun. A person under 21 is allowed to own or possess a handgun.
Great. Any follow-up? Very good. Next on the list, I have Representative Parkinson. You recognize.
Thank you, Mr. Chair. Just a quick question. In the Indiana law for 18-year-olds, they're licensed to carry it. Am I correct?
You recognize to answer.
That is my understanding. Correct.
Very good. Representative Parkinson.
Thank you, Mr. Chair. So, under this legislation, there's no license requirement.
But you recognize, sir.
So my understanding is, yes, it addresses both 3917, 1307G, 1351, and 1366, correct?
Very good. Representative Parkinson.
Thank you for all of those numbers. I have no idea why you gave me those numbers, but sure. But so you know, so there is a there's a. I was just looking up the Indiana law, and there appears to be just a little bit of difference in what we're doing versus what they're doing. But okay, thank you, Mr. Chair.
Thank you. Members have any other questions for Mr. Mayor? Representative Griffey, you recognize, sir.
Thank you, Mr. Chairman. Mr. Mayor, I don't know if you recall, maybe this is a question for legal. When did the state of Tennessee prohibit the storing of firearms in a vehicle on school property? What year did that? Because I may be wrong, because I'm 59 now, but I kind of remember in high school that there were folks with gun racks in the back of their pickup truck, and they were stored in the parking lot, and we never really had any problems. So, I don't know.
Very good. And Mr. Mayor, if you know the answer to that question, if not, I've heard him over here already, so I know it.
Thank you. Did you recognize me?
I sure did. Yeah. I did recognize you. Thank you.
Mr. Chair, if you know the answer, feel free to share it, because I admittedly don't. The only thing that I do know is I had a conversation with the, at the time, governor of Kentucky, who told me a similar experience about the bring your rifle to school day back when he was a student. So it must not have been forever ago, but it was before I started paying that close attention to firearms law as I do now. Thank you, though.
Very good. And that was done when the criminal code was last rewritten in 1989.
Thank you, Mr. Chair.
But it could have been before that. So somewhere around in there. So I guess it was a pretty big rewrite. So, all right. Members, any other questions? Representative Griffey?
I was just going to say I graduated in '81, so that's why I got it. Anyway, I just I appreciate the bill. I think if someone is, capable of being requested to go off and fight and die for your country, that they ought to be able to have a firearm and possess a handgun to protect themselves and their family or other loved ones and from any criminal behavior, potentially death. So I appreciate this effort. Thank you.
Very good, and thank you for your testimony. Wasn't trying to be rude to you at all. Just trying to. You always done a great job. You're well researched and very, very professional, and appreciate you coming up here and being involved in this issue. Members, any other questions for our speakers? Seeing none, we have next on the list. I have Garrett Floyd. Garrett, are you here? There you are, sir. If you go ahead, just make sure the red light's on, and you're more than welcome to stand there and speak. And you have 3 minutes and plenty of time for questions. Perfect.
Is this working? All right, good. Good afternoon, all. My name is Garrett Floyd. I'm very glad to be here today to talk about why I'm passionate about this bill, 1735. This bill is a solution to a problem that matters a great deal to me. Something I'm very passionate about is personal safety. My personal story begins with personal safety starts when I was 19 years old. I was traveling with my dad, and we encountered a person who held us up at gunpoint and was demanding our money. Thankfully, there was enough space between us and the person. We were able to use some other barriers in between us, and we were able to run away. Nothing happened after that. Thankfully, nothing happened. However, the only point that I want to make with that story is this, that we live in a violent world, and interactions like mine are surprisingly common. After that experience, I dedicated time and treasure to build up skills to become more competent in self-defense, and most of my training consisted with conflict de-escalation, avoidance. I dabbled with some martial arts, and the use of non-lethal tools, as well as firearms training. I personally have concealed carried for 6 years. Regardless of all the individual disciplines, each skill is just another tool that can be used to protect yourself and those that you care for. The right to self-defense is one of the things that differentiates the U.S. from many other countries around the world, and the fact that citizens are allowed to carry arms on their person for the purpose of self-defense is similarly unique and something to be grateful for. The current problem with the way things are in Tennessee is this. Between the ages of 18 and 21, an adult cannot conceal carry a firearm. Adults, for a span of 3 years, cannot use a tool which is effective for self-defense. What I present is if adults can own firearms, they should be able to use those firearms or have those tools available to them for self-defense purposes. The passage of this bill is important because law-abiding citizens who are currently vulnerable should not be at risk simply because they obey the current laws.
And thank you for that, members. We're getting short on time. I'm going to try my best to get through these speakers and then back on the bill to get it disposed of one way or another. Does anybody have any questions for our speaker? Seeing none, and thank you so much for your time. Of course. Appreciate you being here. Next on the list, I have James Fry. James, are you here? Looks like James is here. You're more welcome to stand at the podium. If you want to sit down, just make sure the red light's on, introduce yourself, and you'll have 3 minutes as well.
Yes, sir. Thank you. My name is James Fry. I'm here to testify on behalf of HB 1735. I'm 18 years old, and I would like to explain why it's important to me personally that this bill passes. The law deems me old enough to fight, kill, and die for my country, and train with taxpayer dollars to use full auto firearms to kill on behalf of our government. Yet I am not allowed to carry a handgun for my own protection. When either work or social activities require me to be outside at night, I'm always at risk of getting mugged, kidnapped, or potentially even killed by an assailant who is physically stronger than me. This is not far-fetched. You only need to turn on the local news at night to hear about murders, human trafficking, and other violent crimes being committed in and around Nashville virtually every day. I want to say that I have been threatened with a weapon before. While assisting on a political campaign, a gun was drawn on me and my friends. I was staring down the barrel of a gun, and if that man had decided to begin shooting, I would have been helpless. I called the police, and at least 10 minutes later, it was at least 10 minutes till they got there. That would have been far too late should he have decided to pull the trigger. I'm old enough to vote, old enough to drive, old enough to defend our country, and I need the right to defend myself as well. Other states, such as Indiana, allow 18 to 20-year-olds to carry firearms and have not had problems with it. When I turned 18, I had to register with the Selective Service, as the law requires me to be registered and available to get drafted, without my consent, to fight for our country. Yet I am not allowed to protect myself. I can no longer count on my parents to be around me most of the time to protect me, and the police are on average 20 minutes away, even in a city. I actually live in a rural country where police are an eternity away. I'm old enough to vote, old enough to protect this country against Russia or China if the president orders me to. I'm asking for the right to defend my life against a murder or very real threat if no other help is available in time. I'd like to encourage you to vote yes on HB 1735. Thank you.
Yeah, thank you for that. Well done.
Yes,
Members,
sir.
do we have any questions for Mr. Fry? All right. Thank you so much.
Thank you.
All right, and then that concludes our witness list. So, members, if we don't mind, let's go back into session. Without objection, we're back into session. Representative Todd, you're recognized on the bill as amended. I know we had a lot of discussion on this. Members, anyone have any questions for Representative Eldridge? You recognize?
Thank you, Chairman. I'd like to request a roll call vote on this bill.
Procedurally, it would need to have been requested by the sponsor in the beginning, or it can be requested by a member of this committee, but just have to have three hands showing that. So we've gotten two. I see three. All right, members, we got three hands, and the roll call's been requested. Chairman Curcio? Yeah, please.
Thank you, Mr. Chairman. Representative Todd, thank you. I just wanted to clarify something that I heard before, and I had to run out. I had a constituent out in the hallway, but I'm back now. So under your amended language, I just want to clarify two things, and I've asked you about one of these before, but under this amended language, it's not just a permitted 18-year-old person, but it would be either permitted or constitutional carry. Is that correct?
That is correct, sir.
Second question is, and because I didn't hear the end of this discussion when I had to step out, under this legislation, if this were to become law, if I'm 18 years old, permitted or not, because you've answered the first question, and I can store my handgun in the trunk of my car or somewhere in my car as long as it's not visible while I'm inside the school building at high school. Is that correct?
If I understand correctly from legal and what they've said over a period of time here, is that would be correct if it's locked and unloaded, has to be unloaded, and that would be the case, sir.
And one final follow-up, because I don't know the answer to this question. Is that how it works now? So if I go to the school and I'm a constitutional carry or I'm permitted, as long as my handgun is locked and unloaded and out of plain sight in my car, am I able to do that now? Is that so? In other words, this would be the same rules for everybody, or would these 18 to 21-year-olds have actually a little bit more leeway than the rest of the folks?
My understanding to your question is that is currently the case.
That's the way it works for everybody now. Right. And this would just, so it's, in other words, same rules apply 18 and up right now as they would 21 and up currently.
That is my understanding.
Is it? Okay, great. Thank you very much.
Very good. Next on the list, I have Representative Garrett.
Mr. Chairman, I call previous question.
Very good. Previous question's been called. Madam Clerk, go ahead and take that vote for us. There was three hands, roll calls requested, and we're going to take a vote.
Representative Bricken? Aye. Bricken votes aye. Representative Clemens?
No.
Clemens votes no. Representative Curcio?
Aye.
Curcio votes aye. Representative Eldridge? Aye. Representative Eldridge votes aye. Representative Garrett? Aye. Representative Garrett votes aye. Representative Gillespie? No. Representative Gillespie votes no. Representative Griffey? Griffey votes aye. Representative Harris? No. Representative Harris votes no. Representative Littleton? Littleton votes aye. Representative Ogles? Not here. Representative Parkinson? No. Parkinson votes no. Representative Ramsey? Ramsey votes aye. Representative Russell? Russell votes aye. Representative Stewart? No. Stewart votes no. Vice Chairman Jernigan? No. Jernigan votes no. Representative Farmer?
Aye.
Chairman Farmer votes aye. Mr. Chairman, you have 9 ayes and 6 noes.
Very good. Bill passes and moves on to finance.
Thank you, Mr. Chairman of the committee.
And members, that brings us to the conclusion of today's committee meeting. I appreciate everyone being here, being involved, and professional and cordial, and we'll see everybody next week. So without objection, we'll adjourn.